The selection list for today's sitting is available in this room and on the parliamentary website. And I remind members about the rules on declaration of interests as set out in the Code of Conduct. We now come to the question that Clause 19 stand part of the bill, with which it will be convenient to debate Clauses 20 and 26 stand part. Minister.
Thank you very much, Mr Stewart, and a pleasure to welcome you back to the chair for what is obviously a marathon session this afternoon. Clause 19 provides definitions for the key expressions used in relation to the electronic devices measure. These definitions mean the measure will only focus the powers on irregular entrants who are in possession of an electronic device that authorised officers have reasonable grounds to suspect contains information relating to facilitation offences under the Immigration Act 1971. Furthermore, Clause 19 sets out what is meant by authorised officers, and this is defined as an immigration officer or a constable of a police force maintained by a local policing body. The aim of the powers is to gain access to information held on such devices on the organised crime groups who help facilitate or plan migrants' dangerous journeys and to save lives from being lost as a result. This clause is integral to define the key expressions in how the powers can be used. Clause 20 enables immigration officers within the United Kingdom of Great Britain and Northern Ireland and police constables of England and Wales only to search an irregular entrant if they have reasonable grounds to suspect they're in possession of an electronic device that contains information linked to a facilitation offence. This power enables the search of a person, property, premises, vehicle or container. This is to ensure that any circumstances where it's necessary to obtain a device, the authorised officer can use the powers to conduct a search. The clause contains safeguards to ensure the powers are used appropriately. Clause 20 provides the measure with clarity over how searches must be conducted in accordance with these powers. Finally, Clause 26 defines any additional expressions referenced throughout Clauses 19 to 23. This will ensure it's clear to users of the powers what key expressions mean. It's important to be transparent about what is meant and to ensure that public and authorised officers fully understand these expressions. I move.
Thank you. Pete Wishart. Oh.
Sorry, we support clauses 19 to 26, but only insofar as they endorse powers which we think already exist to seize, extract and retain data from mobile devices. Clause 19 provides definitions for key terms in sections 20 and 21 relating to the provisions of those clauses to allow authorised officers to search for, seize and retain relevant articles. The definition of a relevant article is anything which appears to an authorised officer to be a thing on which information that relates or may relate to the commission of an offence under section 25 or 25A of the Immigration Act 1971 is or may be stored in electronic form. Can the Minister provide some concrete examples of what the Government thinks such information might consist of, please? Clause 20 gives relevant officers, either an immigration officer or a police constable, powers to search a relevant person, someone who has entered the UK without leave or in breach of a deportation order. Can the Minister explain why subsection 2 does not allow for any more than one search after the person in question has arrived in the UK? This clause gives officers the power to search for relevant articles described in clause 19 as anything which appears to an authorised officer to be a thing on which information that relates or may relate to the commission, whether in the past or future, of an offence under section 25 or 25A of the Immigration Act. This is quite a narrow definition, just electronic devices. Can the Minister reassure the committee that the necessary powers for search for non-electronic items exists elsewhere, please? And in practice, we suspect the power will be used to gather information and evidence to identify smugglers for prosecution, for which, to be clear, we fully support. But most mobile devices are destroyed during or prior to travelling across the Channel. Could the Minister therefore explain whether she expects any of the evidence gathered using the powers in these clauses to be used to support decision-making around immigration enforcement. If these devices are seized, as the former Director General of the Border Force pointed out in his evidence, they may contain useful information about nationality, identity, age and travel history, and may provide valuable evidence when assessing asylum claims. Can the Minister explain how effective these new powers will be in supporting evidence gathering to remove those with no right to be here? Will information gathered using these powers be available to asylum screening teams? Will this evidence be used in immigration decision-making appeals? These sections do not have extraterritorial reach. So can the Minister explain... Extraterritorial reach. So can the Minister explain to what extent the Government envisages these additional powers will make a meaningful difference to smashing the gangs when many of the perpetrators are located outside of the UK? Thank you.
Pete. Again, Mr Stewart, as the Minister said, these new clauses create invasive new search, seizure and retention powers, along with the powers to access, copy and use information contained within an electronic device. These new powers can be applied to any person who arrives irregularly and has not yet been granted permission to enter or remain in the UK. What it does is allow an immigration or police officer to fully search a person, including a search of that person's mouth, and I'm certain the Minister will tell us exactly why that particular qualification is required when it comes to these new powers. Now, Mr Stewart, this isn't the plot and setting of some future dystopian film. This is going to be the UK sea border in the course of the next few months, and this isn't going to be done to hardened criminals who are wandering the streets of the United Kingdom or those associated with violent crime. This is to be done to some of the most abandoned and traumatised people in the world. And these new clauses are where we're starting just to measurably go into police-state territory, because what they essentially are a hybrid form of stop-and-search powers, probably stop-and-search without the due qualifications and the reassurances that we have. Now, I don't know if profiling is going to be a part of this, and I'm interested in the Minister's response to this, but it seems like there's only one profile that's going to be included in all that, and that's every asylum seeker may be subject to these new powers. For these powers to be exercised, there only needs to be reasonable grounds and suspicion, and that a relevant article appears to store some electronic information that relates or may relate to the future or past commission of a facilitation offence. Again, this seems excessively broad, and you would think that practically any person that arrives irregularly to the UK may be subject to these powers. Any information that's received from any of these searches would be used for preventing, detecting, investigating or prosecuting facilitation offences. The property can be retained for as long as considered necessary to assess, examine or copy information or use in proceedings for an offence before being returned or disposed of. Now, I was trying to think why the government wanted these new clauses, and I know they're going to tell us it's all about to help disrupt organised crime and they can make sure they can find particular and specific information on electronic devices, but I think a lot of it's got to do with this following the 2022 High Court ruling that decreed that the Home Office's secret policy to blanket search, seize and retain mobile phones from individuals arriving by small boats was unlawful. And just like the Tories before them, if any particular law which defends and protects people is seemed or deemed to be a little bit more unnecessary, they'll just bring in a new one and just completely override that, forgetting anything to do with the consequences and the implications that this has on people. These new offences clearly compromises a person's right to private and family life. And given the confidential, legally privileged, sensitive, private personal messages, photographs and information, correspondence and data that may be on such mobile devices, you hold this could only ever be the case. And to be fair, the government actually respect that and they acknowledge that as to be the fact. But the ECHR memorandum suggests that the new powers could be distinguished and that phones will not be seized on a blanket basis when these powers come into force. Well, thank goodness for that. It says that the Home Office will issue non-statutory guidance about the use of the power and training which will be required for authorised officers exercising these powers. Well, I think we're going to have to see that pretty quickly, Mr Stewart, because we have no idea about how any of these powers are going to be exercised. Again, we're having to take the Minister at her word entirely when it comes to how this new law will be exercised as we go forward. The thing is, there is no such guidance for parliamentary scrutiny during the passage of this bill, and so it remains entirely unclear how the Home Office proposes to use these wide and invasive new powers. Now, Mr Stewart, I'm distinctly uncomfortable with these new powers once again, and I am disconcerted about how they may be applied and how they be used. And I think there are a number of agencies, once again, have serious misgivings about the type of individuals that will be subject to these new powers. And I think the Minister has to explain herself just a little bit more about how these powers are going to be used, what protections are going to be put in place, and particularly in reference to some of the most traumatised people that we will ever be dealing with in this country.
Chair White.
Thank you, Mr Stewart. I very much welcome this element of the electronic devices measure of the bill. And whilst Clause 22 will give officers powers to seize digital devices that are believed to be used for the purpose of people smuggling, Clause 23 gives suitably trained and accredited criminal investigators to the powers to access the information on mobile devices, phones, laptops, and that will build the evidence base, the history, the connections, and the understanding of the roots of the criminal gangs. Seizing and extracting data from mobile devices is a powerful tool already used by our security services. There are already established Home Office guidelines on this, and these clauses extend those powers and will help enable intelligence-led profiling of irregular arrivals. The key change will lead to great opportunities to disrupt the trade of these awful gangs.
Right, Chris.
Murray. Thank you, Mr Chairman. Just a couple of points I want to make on the seizure of phones. I think we have to be incredibly realistic about the threat that the country faces and how these things are organised. We've seen it developing in complexity and scale, people smuggling networks and trafficking networks going. It doesn't start in France, it goes all the way through European countries, our allies, and then through countries that are very difficult for us to engage with. Some countries that are at war, some countries that are hostile states. And we know, the evidence from the NCA is very clear, that is organised by phone. That is the primary means that these criminals use to orchestrate that. Now, and we know that that is evolving, so it's really important that we give the officials the power to seize those phones in order to understand, firstly, where these smuggling networks are coming from, which is the only way they'll be able to intercede and save people in unsafe vessels, but also to then disrupt those networks later. And we've made a big whole set of arguments earlier on about the insufficiency of deterrence in stopping sea crossings. And Professor Walsh from the Migration Observatory was really clear that the demand is inelastic, and so no matter how much deterrence you do, there will still be some demand rising to meet it, which is why disruption is so important. And we can only do disruption if we have the ability to seize those phones. It's a really important distinction between targeting the demand and targeting the supply of the ability to cross the channel. And on the point about whether these are blanket, no, they're not. The Home Office is clear there will be statutory guidance. The people who seize those phones will be subject to the rules that are properly in place on handling material that is seized from any individual. And they need those powers. And on the point about family life and private life, I mean, it is an absolutely fair point to make, and it's something that applies whenever someone's phone is stolen. And this is a wider debate that we have in society. But the truth is, there is no capacity to only seize part of someone's phone. You can't only seize some data and not, for example, the private text messages or family photographs. It's proper that the Home Office officials who do seize it are subject to the rules that we have in this country about protecting that and returning it when it's decided not to be there. But we can't separate out, and we would be throwing the baby out with the bathwater if we didn't allow the powers to seize it. Thank you very much.
Minister.
Thank you very much, Mr Stewart. The proposed powers will enable immigration officers and the police to search for, seize, retain and extract information from electronic devices, but based on 2 criteria. The first is reasonable grounds to suspect that the person has a relevant electronic device and that it contains information that relates or may relate to the commission, whether in the past or future, of an offence under Section 25 or 25A of the Immigration Act 1971, and that's the facilitation offence. So that's the first criteria. The second criteria is that the person is part of the cohort to whom the powers will apply. The second part is that it have to be an irregular arrival or entrant. Currently, the Illegal Migration Act, which is on the statute book until we get this bill made into an act, allows for blanket seizure and searching for all purposes of all phones. We are repealing that very wide power, and we are replacing it with this one, which is much more targeted than the IMA one it replaces. And the honourable member for Stockton West was hinting, I think, that we should actually use this clause to widen the powers, or allow all of the information on the phone to be used for all purposes in some of the remarks that he made. That's not what we are suggesting. In fact, the Illegal Migration Act powers of seizure were never actually operationalised or put into effect, partially because the sheer capacity of taking everybody's phones off them, downloading it and somehow managing to analyse what's on all of them defeated the powers that be, and the technical ability to do that hasn't been developed yet. So it seems to us, from talking to organisations in the police, but also the National Crime Agency, who follow these things very closely, that the best and most targeted way to get at some of this information is precisely to have these criteria. So there has to be reasonable grounds to suspect, and that is not a blanket thing. Again, these are intelligence-led powers which will lead us potentially to certain individuals, so that we can take a device off them and analyse what's on it. And experience suggests that it can be very revealing what is on such a device. I'm not going to list things here because I don't want to produce a list of what people shouldn't leave on their phones that is essentially public. But we all use our telephones and our phones and our devices in ways that we all know about, and we'd probably be very sobered if we realised how much Apple knows about us, for example, just by looking at its own record. So a lot can be gleaned, but there has to be reasonable suspicion that the individuals whose devices are taken are actually involved in facilitation, not just coming over, not the Section 24, but Section 25, which is the facilitation, the more serious offence. The second thing, the Honourable Member for Stockton West said that he thought these powers already exist. Well, in the Illegal Migration Act, yes, but completely uncommenced and not put into effect, and far too blanket to be useful. Secondly, there is a power to seize, but current power to seize, but that power doesn't enable immigration officers or police constables to search and seize devices in many circumstances at all. Firstly, a person has to be under arrest before that can be done, and we think that as part of our intelligence-led counter-terrorism style powers to defeat organised immigration crime, being able to search a bit ahead, certainly ahead of an arrest, is a useful power. And so that's what these clauses recommend. The Honourable Gentleman asked if the information that may be found on phones could be used for asylum casework. No, we don't think that is appropriate. This is a focused power which allows us to search for information and evidence about organised immigration criminality, not about any of the other aspects of that person's existence, although there are some clauses which we'll come on to later, particularly if other crimes come to light as a result of a search, which would enable us to operationalise the information we have about that.
The question is that Clause 19 stand part of the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. We now come to Clause 20 stand part, which has just been debated. And the question is that Clause 20 stand part of the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. We now come to the question that Clause 21 stand part of the bill. Minister.
Thank you very much, Mr. Stewart. Clause 21 provides immigration officers within the United Kingdom of Great Britain and Northern Ireland and police constables in England and Wales with the power to seize and retain electronic devices. Clause 21 provides a clear and detailed approach for authorised officers about when they're using the powers to ensure that they're correctly and efficiently and effectively used.
Because
Clause 21 gives authorised officers the power to seize any electronic device which has been found under a search under Clause 20 or is not found on a search but appears to the officer to be or to have been in the possession of a relevant person. How will officers determine whether an article appears to be or appears to have been in the possession of a relevant person? What is the evidence threshold for this? I have a similar question for the Minister in regards to this clause as I did on Clause 20. Will these powers be used to gather any evidence to be used in immigration decision-making and appeals? We support the powers in this clause insofar as they go.
Minister.
Thank you very much, and I'm glad the Honourable Gentleman supports the powers, but I want to emphasise to him again that these are Clause 21 is very much within the context of the clauses that we've just voted for. Therefore, it's the more limited power, it's not a blanket power, and it is about... It basically sort of exists within the parameters that I set out in the previous debate. And just to emphasise again, none of the information that will be seized in this context could be used in an asylum case. So it's for the purposes of dealing with organised immigration crime. It's not for wider purposes, unless, as the Honourable Gentleman will know when we come on to some clauses coming up of a criminality that may become available, it can be passed on. But these clauses are limited to collecting evidence and intelligence on organised immigration crime from people who've just entered the country illegally.
The question is that Clause 21 stand part of the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. We now come to the question that Clause 22 stand part of the bill. Minister.
Thank you, Mr. Stewart. Clause 22 we've got a different grouping. Will provide immigration officers using the powers with the duty to pass on electronic devices to other agencies, such as the police. So the clause will be used if an electronic device seized contains information in relation to a non-immigration offence. This is the case that I was hinting at earlier. So clause 22 provides the process to be taken with these types of cases. We cannot seize an electronic device without this process in place, because we may discover information relating to a criminal offence, such as a counter-terrorism offence or an indecent and or obscene material of a child offence, those kinds of offences. We must therefore act in these cases if we discover evidence of such activities on the phone, and therefore in order to act we have to have the processes in place to enable items to be forwarded on to police or any other agency that needs to take possession of the device for their investigation into other criminality. So Clause 22 has a robust step-by-step process to ensure immigration officers know what actions to take forward on the device or what actions to take if the agency we wish to forward the device onto refuses to accept the device for an investigation.
Clause 22 gives authorised officers the duty to pass on seized items which have been found under a search under Clause 21. If there is a reasonable belief that the article or information stored on it has been obtained in consequence of or is evidence in relation to an offence other than the relevant immigration offence. The immigration officer is under a duty to notify someone who has the functions to investigate the relevant offence. What might be the reasons that a person notified under the clause might not accept the article, and what would be an acceptable reason? If a relevant person refuses to accept the article, what are the next steps? We support the powers in this clause insofar as they go.
Minister.
Well, it's a bit difficult to talk about specific circumstances in a generalised way. I mean, the honourable gentleman could perceive that, for example, there may be some material on a phone that police or immigration officer is worried breaks the criminal law in a particular instance. I was talking counter-terrorism and child sexual exploitation as potential examples. If that information were passed on and the relevant authorities that deal with that issue decided it wasn't at a criminal level, then that would be the occasion that the Minister was asking me about. But one would assume with the appropriate training that it's fairly obvious if something would be a worry for counter-terrorism purposes or child sexual abuse purposes, for example, and that with training the police forces can understand whether they have an obligation to try to prevent other criminal activity going on which is not in the category for which the phone was seized originally. But this is something that we have to do once we begin to seize phones for narrow purposes, just to make certain that passing that information on is lawful. And that's what the purpose of Clause 22 in this bill is.
The question is that Clause 22 stand part of the bill. As many are of that opinion, say aye.
Aye.
On the contrary, no. I think the ayes have it. We now come to the question that Clause 23 stand part of the bill, with which it will be convenient to debate new Clause 22. Minister.
I'm going to wait until the honourable gentleman opposite has moved this new clause before I respond to anything that he says on that. So I'm just going to briefly outline what Clause 23 does, and hopefully the honourable gentleman, if he wants to reply, then Mr. Stewart, you can call me again to come back at the end. Clause 23 will ensure authorised officers will be able to assess, examine, copy and use information stored on a relevant article. Clause 23 enables authorised officers to copy the information from electronic devices so that the device can be returned to the owner as soon as possible. This clause is vital to enable authorised officers to obtain the information needed in relation to facilitation offences under Section 25 and 25A of the Immigration Act 1971, to use for the purpose relating to the prevention, detection, investigation or prosecution of such an offence. Very much, therefore, Mr. Stewart, targeted on organised immigration, crime and facilitation of illegal entry into this country. Clause 23 will help the government tackle organised crime groups, protect migrants from exploitation and prevent lives being lost in dangerous journeys across the Channel. Obtaining this information will further focus our approach to tackling organised crime groups, identify as early as possible the trends in gangs and how that's working, their modus operandi, and provide the government with improved information to prevent future fatalities.
Vickers.
Thank you. Clause 23 gives authorised officers the power to access, copy and use information stored on relevant articles that have been retained under powers detailed in Clause 21, and authorises the use of any information retained under this clause relating to the prevention, detection and investigation or prosecution of such an offence. We support the powers in this clause. However, we think it's important to bolster the utility of the powers in clauses 20, 21 and 23, and it's for this reason that we've tabled new clause 22, picking up on the suggestion made by the former Director General of Border Force in his written evidence to this committee. The purpose behind this amendment is that currently Border Force and immigration enforcement are not able to use mobile devices to track illegal migrants on bail. While powers exist for electronic tagging, there are difficulties with these powers and they're not frequently used. At present, mobile devices can only be used for tracking people for serious offences. Under the Investigatory Powers Act 2016, an illegal entry does not count as a serious offence for these purposes. Mobile devices are often used by migrants on bail to report by phone rather than in person, which minimises their risk of arrest and detention on reporting. Without access to location data of illegal migrants, they are able to stay at addresses not listed on their bail forms. In effect, if immigration officers were able to make use of location data from mobile devices, they would be better able to secure compliance with bail conditions and thus reduce the risk of absconding. New Clause 22, therefore, would allow law enforcement to access mobile phone location data of people who enter the UK illegally. It does this by adding illegal immigration to the Investigatory Powers Act 2016 as a serious offence that allows location data to be used. We would also amend the Immigration Act 2016 to allow a person's mobile phone location data to be used as part of electronic monitoring for immigration enforcement. Of course, migrants can change phones, but they are more likely to make use of them than electronic tags, and so in our view, this new clause would add a useful new power to immigration enforcement teams. I'd be very keen to hear the Minister's view.
Thank you very much, Mr. Stewart. New Clause 22 proposes an amendment to Section 86, 2A of the Investigatory Powers Act 2016. I don't think this proposal is necessary or appropriate. The Investigatory Powers Act provides law enforcement and other relevant public authorities with the ability to covertly acquire communications data where necessary, where it's necessary and proportionate to do so. And I think that members of the committee should particularly focus on the seriousness of the powers that are conferred in the Investigatory Powers Act. The ability to covertly acquire communications data where it's necessary and proportionate to do so. So the question with New Clause 22 arises whether it's appropriate to add immigration issues into that area of the law, and whether an immigration issue would be necessary and proportionate to start covertly acquiring the communications of immigration in an immigration setting, in all of those settings, whether this would unbalance the Investigatory Powers Act and lead to some issues that would probably actually weaken it. The Investigatory Powers Act is intentionally neutral on the specific crime types for which the powers can be deployed. And instead it sets a threshold for serious crime to enable access to more intrusive powers. The acquisition of communications data, which is the who, the when, the how, the where of communication, but not the content, that threshold is set out in Section 86 2A of the Investigatory Powers Act. Events data, which includes details of where and when a specific communication took place, is only available for crimes that meet this serious crime threshold. The threshold at Section 86 2A little a is a crime for which a sentence of at least 12 months imprisonment can be handed down. The proposed amendment doesn't define illegal immigration. However, in relation to those immigration offences in Section 24 of the Immigration Act 1971, as recently amended by the Nationality and Borders Act, many of the offences will already meet the serious crime threshold. So there's no real reason to put immigration crime in there. It's already implicitly in there, and starting to add in particular instances will unbalance the way the Investigatory Powers Act actually works. That's a technical point, but it is about keeping our statute book coherent rather than adding things in for effect later on. So essentially, since these offences, Section 24 offences of the 1971 Immigration Act are indictable offences, the serious crime threshold would already be met, and events data can already be acquired as part of the investigation. So we don't need to go through this rigmarole to emphasise what is already possible to do. Where these offences don't meet the serious crime threshold, it would not be proportionate to extend the use of events data to those crimes. The right to private and family life is set out in Article 8 of the Human Rights Act 1998, and it's important that we uphold our obligations to the European Convention on Human Rights. Now, I know it's not always the most popular thing with the party opposite, but as someone who actually voted for it in 1998, I'm still quite proud of it, and I think that actually defending our human rights and ensuring that these things are proper and proportionate and lawful is actually quite an important part of trying to pursue and deal with difficult cases, but at certain standards of behaviour. While Article 8 is a qualified right, we must ensure that interference remains necessary and proportionate to the level of criminality. By introducing specific crime types that don't meet the sentencing threshold, we risk eroding the safeguards that are in the regime. And by taking away rights of people that may seem marginalised at the moment, I would submit that we're actually putting at risk our own rights and human rights in general, and that is not something that I would want this government to do. The amendment to Schedule 10 of the Immigration Act is also unnecessary. Where a person is subject to electronic monitoring as a condition of their immigration bail, the Home Office is able to access their location details via the GPS tag or non-fitted device. There's no need to access mobile phone location data because there are already powers to monitor the whereabouts of individuals at risk of absconding. So I hope that, having had the debate, the Honourable Gentleman will realise that these things are already covered in the way that we currently do things. I hope he'll withdraw the new clause, but obviously we won't know until we get on to voting for it, which will be sometime in the future.
The question is that Clause 23 stand part of the bill. As many are of that opinion, say aye.
Aye.
On the contrary, no. I think the ayes have it. We now come to the question that Clause 24 stand part of the bill, with which it will be convenient to debate Clause 25 stand part. Minister.
Thank you, Mr. Stewart. Clauses 24 and 25 of the bill deal with amendments to the Criminal Justice and Police Act 2001, extending these powers to other authorised officers and key definitions in the clauses. Clause 24 includes amendments to the Criminal Justice and Police Act 2001 to extend powers of seizure where a device may contain legally professional privileged material, excluded material and special material. Criminal Justice and Police Act also contains essential safeguards for the handling of such material. Extending the powers of the Criminal Justice and Police Act will ensure that the seizure of any device will not be prevented by claiming that it holds legally professional privileged material and excluded and special material, which is often an excuse, I have to tell you, Mr. Stewart, that is raised when these matters come up. Furthermore, Clause 24 will ensure that this data is protected, but operationally the information needed can still be taken for the purpose of these powers, and seized electronic devices returned as soon as reasonably possible. Clause 25 provides the Secretary of State with the ability to extend the powers to other authorised officers via secondary amendments if they are required to deliver these powers to support the disruption of organised immigration crime. The Government will ensure any decisions on extending the powers to other authorised officers will be fully considered before action is taken. I move.
Vickers.
Clause 24 amends the Criminal Justice and Police Act 2001 so that provisions relating to the protection of legally privileged material and excluded and special material apply when mobile devices are seized under clauses 20 to 23. Can the Minister explain how often the Government envisages these provisions would need to be invoked in practice? Clause 25 allows the Secretary of State to make regulations to extend the powers given to authorised officers in clauses 20 to 23 to be available to other people, including people designated by the Secretary of State. Can the Minister explain why these powers might need to be extended to different categories of people? Who does the Minister have in mind? Why is this not included on the face of the bill? Can the Minister also explain why these powers are subject to the negative procedure? Why was this judged to be appropriate? Clause 26 defines key terms used in the preceding clauses, and we have no problem with those definitions.
Will Forster.
Thank you, Mr Stewart. The clauses 19, 23 are very wide powers. Often police constables only have these powers when they're authorised and monitored by their superiors. But the powers in this bill almost allow civil servants and immigration officers to do so without oversight. But clause 25 allows ministers to extend those powers to privately employed staff, one, and then does so without ministers requiring to give directions of exercise of those powers. And that does sit very broadly with me. I'm quite concerned about that. I can understand the idea of why we need some broad powers, and I was happy to let the others go through on the nod. But clause 25 seems to go further still. Could the Minister try to reassure me or us, particularly, would they agree to issue directions for use of those powers before either today or MPs fully vote? That is not. I think there'll be some colleagues out there that go the private sector should not have these powers. But if they are clearly identified and statutory guidance is issued, I will be a lot more reassured. Thank you.
Thank you very much, Mr Stewart. I think the first thing to say is that the powers under the Criminal Justice and Police Act are already used by law enforcement and apply in many statutes, and therefore all of these powers will be used to ensure compatibility with ECHR protections and also GDPR protections. So and data protection. Generally, we've got a very high level of expectation when it comes to data protection in these instances. The Honourable, I think both Honourable gentlemen who've spoken in the debate have asked about the extension to further authorised people that is potentially available as part of this clause. It isn't unusual, and the Honourable gentleman, the member for Woking, has made this point. It's not unusual for the government to hire and use contractors, both short-term and on a long-term basis, dependent on demand or business needs. And I suppose one of the examples that comes to mind in this context would be a forensic data specialist, for example, to do analytics of the information that had been downloaded. And so this is about, I'm very sorry if that's me.
No. It begins.
Hopefully it's not. And some of this is about ensuring flexibility in the statute within the protections that I've just talked about with GDPR and data protection legislation and ECHR requirements, to be able to deal with the information that was coming in all circumstances without having to come back to primary legislation. And clearly those people would be working under the same expectations and requirements from use of data protection as as working for the Home Office as any directly employed person. The negative procedure is just really a flexibility issue that this isn't, I don't think, as serious an extension as those who were thinking that the government was trying to instigate some kind of Stasi-style state would think it is. It's just a question of if there was somebody who, some organisation that had particular expertise in a particular issue that we needed to get in to help process and deal with this kind of data in an appropriate manner. We would be able to do it without being constrained in primary legislation. I hope that reassures honourable gentlemen.
The question is that Clause 24 stand part of the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. Clause 25 has just been debated, and the question is that Clause 25 stand part of the bill. As many as are of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. Clause 26 was debated earlier with Clause 19. The question is that Clause 26 stand part of the bill. As many are of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that Clause 27 stand part of the bill, with which it will be convenient to debate Clauses 28 and 29 stand part, and new Clause 23. Minister.
Again, I will try to reserve my answers on the new clause to after I've heard what the front bench opposite have to say about it. This group entails clauses 27, 28 and 29, which cover the arrangements for HMRC to supply information which it holds in connection with its customs functions. The group also covers amendment new clause 23, which I will try and separate out so that I can try to answer the honourable gentleman's questions once he's put them. Government departments like the Home Office and law enforcement partners rely on information sharing for a range of purposes, including law enforcement and border security related purposes. Key data sets are held by HMRC, many of which are held in connection with HMRC's customs functions. Existing statutory provisions to share this information are complex, fragmented and restrictive in ways that prevent the government from taking full advantage of technology such as modern big data analytic tools. Clause 27 will create a new power for HMRC to supply information which it holds in connection with its customs functions to a range of recipients, including UK ministers, government departments, police and certain international partners. HMRC will be able to supply information for use for the purposes of any of the functions of the recipient. The sharing of entire data sets and the use of customs information for more than just customs purposes will enable the Home Office and other partners to analyse the information to identify suspicious activity that would not be apparent if each data set were considered in isolation. This will support key government objectives such as disrupting and dismantling organised crime groups, preventing the unlawful movement of people and goods into the country, prosecuting offenders, protecting vulnerable people, and also the government's Safer Streets mission. Clause 28 regulates how the information supplied under Clause 27 may be used and disclosed by its recipients. The aim is to ensure the information is fully safeguarded, whilst also enabling government departments to use information received for any of their functions, ensuring maximum benefit can be derived from the information received. Information shared under Clause 27 is subject to a general rule. A person who receives it must only use it for the purposes for which it was supplied. and may not further disclose it to anyone without HMRC's consent. There are a number of exceptions to this general rule which will enable certain recipients to use and disclose information more flexibly. However, there will be some exceptions. UK ministers, government departments and police will be able to reuse customs information for any of their functions and further share it between themselves for specified border security and law enforcement related purposes. Additionally, there will be extra onward disclosure permissions for the Home Secretary so that she may disclose the information to any person for use for certain immigration and customs related purposes. Clause 29 regulates how the information supplied onwards in accordance with Clause 28 may be used and disclosed by its recipients. The aim is to ensure the information is fully safeguarded. It focuses on making clear the restrictions surrounding the reuse and onward disclosure of information supplied under Clause 28. Any person supplying information in reliance on Clause 28 or Clause 29 must notify the recipients of these restrictions as they apply to the reuse and onward disclosure of the information. In recognition of the particular importance of protecting HMRC information, which can include a great deal of personal information, Clause 29 extends the existing criminal offence, wrongful disclosure under Section 19 of the Commissioners for Revenue and Customs Act 2005 to apply to any person who discloses information in contravention of these restrictions. The intent of Clause 29 is a continuation of the safeguards laid out in Clause 28, whilst ensuring none of the restrictions go against the spirit of the overall information sharing provision. Clause 29 protects information from being shared beyond the provision's intent. And I move, I'm not going to deal with the Honourable Gentleman's new clause, new clause 23, until he's moved it. The Honourable Lady.
Thank you, Mr. Stewart. We welcome the powers in these clauses to share HMRC data. Border Force is responsible for clearing both people and goods at the UK border. There is international precedent for moving towards joint targeting centres for people and goods. From a law enforcement perspective and from our perspective, the more customs information that can be shared with UK and other government agencies, the better. HMRC has a range of customs functions, including the collection and management of customs duty, monitoring and controlling the movement of goods, and control of cash entering or leaving the UK. HMRC is bound by the statutory framework on confidentiality and needs a lawful basis to disclose information. Clause 27 will allow HMRC to share customs information in support of defending the security of UK borders. This clause allows UK ministers, government departments and the police to reuse customs information for any of their functions, as the Minister of course laid out. This clause also allows data to be shared with international organisations that have functions relating to the movement of goods or cash across international borders, or if an international arrangement makes provision for cooperation between that organisation and HMRC. We welcome the powers in Clause 27. I would like to ask the Minister how often she expects these data sharing powers to be used for law enforcement and her assessment of what practical effects these powers will have in making it easier to disrupt organised crime networks. Clause 28, which we support, specifies the circumstances in which UK government departments, ministers and the police can further share customs data. We also support Clause 29 and the safeguards included in this clause. We have tabled new Clause 23 to disapply data protection laws from data on those who have entered the UK illegally or are foreign national offenders. The purpose of this clause is exactly the same as the purpose of Clauses 27 to 29, which is to minimise barriers to data sharing between agencies for immigration and law enforcement purposes. And we table it in the spirit of support I have already mentioned for the government's aims regarding data access. If someone has entered the UK illegally or is a foreign national offender, law enforcement for removal is vitally important, and GDPR legislation should not stand in the way of being able to gather and establish any necessary evidence for use in immigration appeals or in law enforcement. We wish to remove the barriers to data sharing in these cases, as we know the government does, and we hope they will find the suggested amendment useful.
Minister.
Looking behind me as well, just to check. Well, I thank the Honourable Lady for moving her new Clause 23 And as she said, it seeks to disapply the protections afforded by the UK GDPR regulations in relation to people who've entered the UK illegally or who are foreign criminals. If I might say so, I think that that will massively complicate data protection legislation, given that we'll always have to be keeping an eye on who is a foreign national criminal or who is an immigration offender over time as well as in the moment. And I think that that could actually make it harder to apply some of the data sharing rules. I think we believe that with the protections that are in the clauses 27 through to clause 29, we can get and share the information that we need to share to its greatest effect whilst protecting people from the unlawful disclosure of it without complicating things further in trying to check whether somebody's a foreign national offender or whether they entered the country illegally. We have a strong history of maintaining high data protection standards. The legislation permits the use of personal data for legitimate purposes such as immigration control, while giving the public the reassurance that such use will be subject to proportionate safeguards. So I think our approach would be to rely on the proportionate safeguards rather than to disapply the entirety of data protection laws to certain groups of people who happen to be in our society at the moment. We just think that that's the proportionality test with the focus on organised immigration crime is important. Yes.
Becky Gibbons.
Thank you, Chair. And thank you to the Minister for giving way. Does she agree with me that the lesson learned from the previous government and the blanket application of some seizure powers under the IMA being so complicated that they weren't actually enforced properly, as we learned from one of our witnesses, that the application was so complicated that it wasn't properly used, is a precautionary tale for the reasons why the new Clause 23 should be rejected?
It's certainly a good idea if when one is legislating, one creates legislation that's actually capable of being commenced. That's otherwise we're just all having fun time in committee, and it's not actually ever. I can see everybody agreeing with me, and it's not actually about affecting the statute book or making it easier for the things that have to be done, and enabling the law to assist in doing that rather than just be a gigantic problem. So I'm certainly, as a Minister, in favour of enacting laws that we can commence, and I certainly hope that we'll be able to commence large parts of this bill as soon as it's made its proper progress through both houses. Mr. Stewart. I was also saying that the UK has a long history of maintaining high data protection standards, and I think complicating them by trying to say that certain people, individuals who are in our society, whether we want them to be or not, would have that disapplied, implies that we would have to keep very up-to-date, very regular records of every single person in the country to see what their status was, which rather sounds like ongoing identity checks across the whole population, which is easier said than done. Not government policy, and I didn't think it was opposition policy either. So I think that this is, whilst well-meaning, it's a complication rather than something that would assist. Where the exercise of data subjects' rights, such as the right to seek access to personal data, could undermine the tasks, appropriate exemptions can be applied on a case-by-case basis. Disapplying data protection rules in a blanket fashion for certain groups is unnecessary and could disadvantage some of the most vulnerable people in society, such as victims of trafficking. So I hope the Honourable Lady will withdraw her amendment on that basis, but with the reassurance that we think that combination of these clauses will give us the powers to use big data and big data analytics, but in a way that is in keeping with the data protection laws of GDPR and the ECHR.
Come back in if you wish to, but not if you don't.
I take the Minister's points about practicality, but of course in situations when new clause 22 did in fact create additional complexity, the Home Office would retain the option to adhere to GDPR if it wished to. It just would not be forced to. We really think this would be a useful addition, and we hope the government will consider it further. But we will withdraw it, though we have not yet been asked to move to that. Apologies. Indeed.
Comes at the end, the new clauses. The question is, clause 27 stand part of the bill. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. Clause 28 has just been debated. The question is that clause 28 stand part of the bill. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. Clause 29 has also just been debated. The question is that clause 29 stand part of the bill. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 30 stand part of the bill, with which it will be convenient to debate clause 31 stand part. Minister.
Thank you very much, Mr. Stewart. This group includes clauses 30 and 31, as you've just announced, concerning the sharing of trailer registration information. Clause 30 creates a clear discretionary power for the Transport Secretary, and in practice DVLA, to share some or all of the trailer registration information they hold with the Home Office for specified purposes related to border security and law enforcement, with the National Crime Agency and HMRC for use in connection with their statutory functions, with policing bodies for policing, law enforcement and safeguarding national security purposes, and with specified persons in the Crown dependencies in Gibraltar for purposes equivalent to their UK counterparts. This measure is designed in recognition of the limited time frames law enforcement bodies have to review information and take decisions when risk assessing the thousands of lorry movements coming into the UK on a daily basis, to prevent, detect, investigate and prosecute crime, and for checks at the roadside. Border Force intends to use this information alongside customs and other information they hold to develop a richer picture of vehicle movements and to enable timely interventions. For the police, the National Crime Agency, HMRC and recipients in the Crown dependencies in Gibraltar, its value will be realised via the law enforcement data system to provide on-demand information at the point of need.
Will the Minister give way?
Happy to.
I thank the Minister. Thank you, Chair, and I thank the Minister for giving way. I'm sure all of us will, when we cast our minds back to 2019, remember the awful case where 39 Vietnamese migrants died in the back of a trailer in Essex. Reading some of the reports of what people found when they opened the lorry and hearing about people dying in excruciatingly painful ways, it just really makes us all realise in this committee how everything that we're doing is about trying to stop harm to vulnerable people and to try and save lives from being lost. Would my honourable friend agree with me that with this grouping, with this clause, it's going to be easier for data held by DVLA to be shared with our on UK registered trailers, to be shared with our law enforcement and police, and as a consequence we might be able to avoid yet more misery and yet more loss of life in such excruciating circumstances?
Yes, certainly, Mr. Stewart. That is one of the, at the higher end of harm, the things that one would hope access in a more timely fashion to this kind of information could actually deliver as a result. The clauses that we're discussing will ensure that those charged with securing the border and beyond can use the information in line with the range of threat types enabled through cross-border lorry movements, like the one my honourable friend was just talking about, ensuring that the law enforcement community engaged in tackling organised immigration crime and wider serious and organised crime are able to do so at pace. Clause 31 complements Clause 30 by setting out how information received by the Home Office and the police may be disclosed onward, with whom and for what purposes. Robust interagency and international cooperation is crucial to smashing the criminal gangs. Border Force routinely works with the National Crime Agency and the police for the purposes of criminal investigations connected with the smuggling of people and illicit goods, and with HMRC for customs purposes. The police in turn need to be able to alert law enforcement partners to identify specific trailers of interest. Border Force and the police also need to be able to alert European law enforcement partners to intercept trailers where there may be a threat to life, and in support of cross-border cooperation against illicit goods. This clause, subject to safeguards contained in clause 32, enables just such an outcome to be achieved, I move.
Thank you, Lynn.
Thank you very much, Mr. Stewart. Clause 30 provides a power for the Secretary of State for Transport to supply trailer registration information to the Secretary of State for the Home Department for immigration purposes, law enforcement purposes, human welfare purposes, purposes connected with functions under the Proceeds of Crime Act 2002, protecting national security and responding to an emergency. This information can also be shared with the National Crime Agency and HMRC. We support the powers in this clause. As with the previous group of clauses, this is about being able to bring together the information being held by different arms of the state to defend the border, with which we wholeheartedly agree. In truth, I must confess it's going to be a fairly friendly section of the afternoon, Mr. Chairman, for which I can only apologise to all involved. Clause 31 provides powers for the onward sharing of information in Clause 30. We believe it is important that this information can be shared with those exercising public functions, including those outside the United Kingdom. We also support the new powers in this clause.
The question is that clause 30 stand part of the bill. As many are of that opinion, say aye.
Aye.
On the contrary, no. I think the ayes have it. Clause 31 has just been debated. The question is that clause 31 stand part of the bill. As many are of that opinion, say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 32 stand part of the bill, with which it will be convenient to debate clause 33 stand part. Minister.
Thank you, Mr. Stewart. This group includes clause 32 and 33, which provide for safeguards with respect to the customs and trailer registration information sharing provisions, which we've just agreed stand part of the bill, as well as providing clarity about the meanings of terms within those clauses. Clause 32 makes general provision about the disclosure of information with respect to clauses 27 to 31. That is information held by HMRC in connection with its customs functions, as set out in clauses 27 to 29. The DVLA's trailer registration information in clauses 30 to 31, and it does two things. Firstly, it clarifies that clauses 27 to 31 do not limit how information may be disclosed outside of the scope of this legislation. That is, it does not tie the hands of a named party to disclosing information subject only to the regime established here if another information gateway exists. Secondly, it clarifies that nothing in clauses 27 to 31 authorises disclosure where it would contravene UK data protection or investigatory powers legislation, but that in deciding on that, these clauses are to be taken into account. Clause 32, therefore, neither treads upon other legal regimes to disclose information outside of the scope of this legislation, but nor does it permit anything that would fall foul of existing statutory safeguards. A perfect, balanced approach, I would submit to the committee. Clause 33 makes provision for the interpretation of clauses 27 to 31, the terms used, their scope and the limits. Firstly, it defines the meanings of certain terms through direct definition and in reference to other legislation. Secondly, it seeks to capture all UK police forces and bodies who may be the end users of the information, referring to a UK authorised person and a UK authorising officer in clauses 30, and defining what it means in this clause. The use of the term UK authorising officer and the person under whose direction and control the constable is avoids reliance on references to chief constable, commissioner and chief officer, as those terms have prescribed legal meanings that exclude the commanders of the very important Ports Police and especially the even more important Mersey Tunnels Police, who rely on other ranks to command. So that ensures that these definitions apply to everybody, whatever the context of the force. And obviously the Ports Force and the Mersey Tunnels Police are an extremely important part of defending the border for obvious reasons. For UK authorised person, the term constable, which includes special constable, is used. The clause also refers to other person who is under the direction and control of a person who has the direction and control of a body of constables. Such is the poetry of legislative diction, Mr. Stewart, but lawyers know exactly what that means, I can assure you. Instead of police civilian staff or similar terms with prescribed meanings, we have that rather long and convoluted explanation which includes everybody. This is because not all forces employ police staff subject to employment contracts. Some also use police volunteers. The MOD police uses civil servants in such roles, while the Police Service of Northern Ireland has powers to use civil servants separately to employed police staff. Use of other person accommodates all of these cases, and so is all-encompassing. Hopefully we haven't missed anybody out. Thirdly, and this only applies to the trailer data, we've worked with the Crown Dependencies in Gibraltar to identify persons undertaking statutory functions equivalent to their UK border security and law enforcement counterparts, defined them as a non-UK authorised person, and specified them in a table besides the authorising officers. And finally, the clause establishes a regulation-making power for the Secretary of State to define the meaning of specified purposes related to policing, to ensure the data requirements of the police are met today and can be updated from time to time as operational requirements evolve. It's subject to a prior consultation requirement, if there should be such an extension, with policing bodies across the UK, the Scottish Ministers, the Department of Justice in Northern Ireland, and the affirmative resolution of both houses. And with those reassurances, I hope members of the committee will be happy to support clauses, the clauses 32 and 33.
Katie Lamb.
Thank you, Mr. Stewart. Clause 32 makes general provision about the powers of disclosure in clauses 30 and 31. Subsection 2, as the Minister laid out, clarifies that nothing in clauses 27 to 31 authorises disclosure where it would otherwise contravene data protection legislation or investigatory powers legislation. I'd like to ask the Minister how much difficulty she envisages these provisions might cause for the sharing of some information and seek some reassurance, she has offered some already, that the safeguard will not frustrate legitimate data sharing activities. Clause 33 defines key terms included in clause 27 to 31, and we have no issues with this clause.
Minister.
I'd like to just reassure the Honourable Lady that we don't envisage that the definitions or in these clauses will cause any problems, any practical problems with data sharing and the powers that have been defined in clauses 27 to 30.
The question is that clause 32 stand part of the bill. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. Clause 33 has just been debated. The question is that clause 33 stand part of the bill. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 34 stand part of the bill, with which it will be convenient to debate clause 35 stand part. I turn to the Minister once again.
Thank you very much, Mr. Stewart. Clause 34 is critical for the Government's ability to manage crises and support evacuations effectively. Where the UK Government is considering or has facilitated an individual's departure from a country in crisis, it's essential to lock in identity and conduct necessary biometric checks at the earliest opportunity for obvious reasons. Clause 34 ensures that there is a clear legal framework for collecting biometric information outside the UK in these exceptional circumstances. The clause includes important safeguards, particularly for children, ensuring that biometric data is collected responsibly. This provision reflects the UK's commitment to maintaining both security and efficiency in high-risk international evacuation situations. Clause 35 details the government's approach to the use and retention of biometric data gathered under the previous clause. It sets out the circumstances in which the Secretary of State may use the information, namely in connection with their duties relating to immigration and nationality, along with law enforcement and national security. In line with data protection legislation, the information will only be retained if this is necessary and will be destroyed when either no longer needed or within 5 years. This clause contains an important set of safeguards which protects the data of individuals in scope of Clause 34, and I move.
Katie Lowe.
Thank you, Mr. Stewart. Clause 34 provides a power for an authorised person to take biometric information where the government is in the process of facilitating their exit from a state or territory. The purpose of this power is to ensure that only those who qualify under particular evacuation schemes are able to come to the UK. The power to take biometric information set out in this clause should help to verify identity and conduct screening checks, as individuals in these circumstances are often undocumented. We fully support this and would be interested to hear more about whether the government intends to take further action on biometrics, which perhaps they might bring into this bill. Other countries like Dubai and Singapore are investing in biometric entry and exit systems, as is the EU. The UK does not routinely capture biometrics at the border, although with the new UK electronic travel authorisation, we will collect digital photographs of all non-visa nationals with the option of retaining fingerprint scans as well. We are aware that there are, of course, both logistical and financial challenges to enabling Border Force to collect biometrics routinely from all passengers on arrival and departure. But there are also substantial benefits, including helping match illegal migrants and asylum seekers leaving the country and giving a clearer picture of those who are overstaying and more accurate migration figures. We would be interested to hear how the government is thinking about biometrics more broadly in the context of not extending the power to capture biometrics more widely in this bill.
Minister.
Thank you very much, Mr. Stewart. Clearly, the potential for having electronic borders and much more sophisticated approaches to the hundreds and hundreds of millions of journeys that cross our borders every year is an important part of certainly my colleague, the Honourable Member for Feltham and Heston's day job. This is a more limited clause, and I have to say that we are certainly investigating both the potential and cost and benefits of having a much more digitalised border. I don't think that we're about to introduce it in this bill, if I could put it that way for her, but I'm sure that there'll be much more to be said about that when that work has been done in due course. We certainly understand the potential for making border crossings much more convenient for everybody, whilst there being much more robust information about who has crossed borders when and where. And clearly, some of what we've been talking about is about goods crossing borders, trailers crossing borders, a range of other things, and people smugglers also ensuring that clandestines cross borders too. Yes.
Thank you, Chair. I note under Section 3 of Clause 34 that there is a requirement for an authorised person only to take biometric information from a child under the age of 16 with their consent, or if they are under 16, if they're in the presence of a person aged 18 or over who is the child's parent or guardian, or a person who for the first time being takes responsibility for the child. Can I ask my honourable friend, does she agree with me that we ought not to disapply the requirement for consent on such tests for children who are under the age of 16?
Well, it is important that we uphold standards and have those requirements, which is why the clauses that we're debating do that. The particular issue that these clauses deal with is the need for, in an emergency situation, evacuation of people who are British citizens and or who potentially live in families that have British citizens in them, but being able to get them to safety, but at the same time be able to take information about who they are, biometric information, so that we can check who they are. It's obviously much more effective for us to do that at the earliest opportunity rather than to get them to the UK and then have to do it, or to get them on UK territory and then have to do it. And certainly that is why these clauses will put us in a much better situation from the point of view of identity and security checks. And we hope it doesn't happen, there should have to be an emergency evacuation of British nationals from a particular place in the future.
The question is, that clause 34 stand part of the bill? As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. Clause 35 has just been debated. The question is, that clause 35 stand part of the bill? As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 36 stand part of the bill. Minister.
Thank you very much, Mr. Stewart. Clause 36 will enable the biometrics of persons detained in Scotland under Schedule 8 of the Terrorism Act 2000 and Schedule 3 of the Counter-Terrorism and Border Security Act 2019 to be taken at ports, thereby bringing the position in Scotland into line with that which already exists in England, Wales and Northern Ireland. Schedule 7 and Schedule 3 allow an examining officer, that is a constable or a designated immigration or customs officer, to stop, question, search and detain a person at a port or at the border area in Northern Ireland for the purposes of determining whether the person appears to be the person who is or has been engaged in terrorism or hostile activity, respectively. An examining officer may stop and question a person whether or not there are grounds for suspecting that the person is or has been engaged in terrorism or hostile activity. These are important powers that allow counter-terrorism police officers to detect, disrupt and deter terrorism and hostile activity at the border. The powers for taking biometrics in Scotland are contained in paragraph 20 of Schedule 8 and paragraph 42 of Schedule 3. This clause amends those paragraphs, removing the unnecessary restriction, which is unique to Scotland, which requires those detained under these powers to be taken to a police station in order to have their biometrics taken. Therefore, it will allow biometrics to be taken much more easily and more quickly in situ, rather than having to transport the person in question to a police station. And I move they stand part of the bill.
Katie Lamb.
Thank you, Mr. Stewart. Clause 36, as the Minister has laid out, extends biometric powers to ports in Scotland. As we understand it, immigration enforcement already has powers to take biometrics from people arrested in the UK, including at ports, if they are suspected of having entered or remained in the UK illegally. So I would be interested in what the Minister's view is of how this clause will add to operational powers beyond what exists already.
It's a lacunae in Scotland rather than a problem elsewhere, simply that biometrics can't be taken except in a police station in Scotland. I think that the independent reviewer of terrorism legislation recommended that we address this issue in 2020 in his report on the operation of the Terrorism Acts 2000 and 2006. We saw an opportunity to deal with what is obviously an unintended kink, and so we're ironing it out.
Sorry, so that's right. I'm just checking that I fully understood what the Minister said. It's very helpful. So the power already exists, but it's about locational flexibility. Is that right? Thank you.
At the moment, under Scottish law, biometrics in this instance have to be taken in a police station. Everywhere else, they can be taken in situ, and we're just bringing into line the situation in Scotland. It's a minor change, but it'll have a good and important practical effect.
So the question is that clause 36 stand part of the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it.
I beg to move that further consideration of the bill be now adjourned.
The question is that further consideration of the bill be now adjourned. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. Good afternoon.
See you next week.
Committee Room 9, Sound. Committee Room